Attend the court.
Please be seated. Good morning, full house. It's been a while. All right, this is S-1-SC-39211, State versus Hice. Can I have entries of appearance, please? Ms. Jaramillo, it appears that you have designated 25 minutes for your argument in chief and reserved 5 for rebuttal. Is that correct? All right, you can take the podium.
Good morning, Your Honors. May it please the court. Mark Hice testified at trial that when he shot into the passing Subaru, he was acting under genuine fear. His reaction may have been unreasonable, but his fear was real. Because he admitted to the shooting in this case, the only issue left for the jury to resolve was his intent. The district court should have instructed the jury on voluntary manslaughter. This is important because voluntary manslaughter does not require the defendant's act of killing to be. Sorry, that's not mine.
That's not you.
That's not me?
No. Robert, please turn down the volume. See if that works. It's like our own version of Siri.
Okay.
There you go.
This is important because voluntary manslaughter does not require the defendant's act of killing to be reasonable.
Ms. Jaramillo, does
Yes.
it matter that a manslaughter instruction was not tendered to the court?
Your Honor, I don't think it matters in this case. I think the voluntary manslaughter issue was preserved. Here, defense counsel asked for an instruction on provocation. And I think both of the parties and the district court understood that that was a preliminary issue to getting to voluntary manslaughter. So if the district court rejected provocation, then there's no reason to give a voluntary manslaughter instruction. Had the district court agreed and given a provocation instruction, the uniform jury instructions require that voluntary manslaughter then be given.
Was the shooting reasonable?
Well,
How many shots were fired?
Mark fired probably 9 shots, I think was what the testimony was, and his co-defendants, one of them emptied a full gun, so there was a large number of gunshots.
So what about the well-settled rule that the victim must have been the one that provoked the defendant? Are you asking us to overturn that rule? Because that seems to cut entirely against your argument.
Right. I am asking this court to modify that rule. I don't think our cases have squarely addressed this situation. The court in Coffin discussed this conflict in the cases between Griego and Gutierrez, but left open whether transferred intent can apply to voluntary manslaughter. I think, and then the other cases that we have, for example, Griego, in that case, it was a party on New Year's Eve. The defendant was fighting with one man, and while blind with anger, stabbed a different person, and the court held his intent transferred to that other person. Specifically, the court stated, if a person intends to kill one person and unintentionally kills another, his guilt or innocence is to be determined as though the fatal act had caused the death of the person against whom the act was directed. And so this court upheld the voluntary manslaughter conviction in Griego basically on a theory of transferred intent. Other cases, such as Gutierrez, in that case, the defendant's wife called him, said she was leaving him. He became very upset, threatened to kill himself and the children, and then killed his baby. And the court held any provocation caused by the wife does not transfer to mitigate the killing of the child.
But her question is whether the victim provocated, and that the Sloan announces that and relies on Jim.
Right, and Sloan is another case that is not factually similar because in that case, the accomplice was the source of the provocation. The victim.
But it says in Sloan, it is settled law that the victim must be the source of the provocation.
Right.
To me, that's pretty clear. So are you asking us to overturn Sloan? We'd have to, I
don't think you have to overturn Sloan to get here. This court could, but I think under Sloan, that and Jim also, those are cases that involve provocation by an accomplice. In Sloan, the defendant shot the victim at the direction of the co-defendant. We wouldn't allow a claim of duress either in that circumstance. This is different because Mark was mistaken about who was in the car, but his fear
Well,
was
it's the
genuine.
conduct of the car in relation to him that caused him to shoot, according to your theory. And so the quote, victim is the occupants of the car, whoever it is, that
Right.
they're all participating in that conduct. Is that one way to look at it?
I think that is one way, but that's a narrow view because I think the district court is correct. The driving behavior on its own of the Subaru is not sufficient provocation.
Isn't that all we have
No, we
here?
also have everything leading up to,
No, because for the provocation, we have separate events, essentially 3 separate events happening here. And there's nothing to tether the erratic driving of the Subaru to what happened earlier in
there's
the
Mark's
day.
belief that that was Louis in the car. And
But the
so-
belief has to be reasonable and it has to be based on the average Joe, not somebody who's
under,
high out of their mind.
right, and under our uniform jury instruction has both a subjective and an objective component to provocation. And the jury instruction says provocation can be any action, conduct, or circumstance. And so, and in Benavides, which was a 1980 case from this court, the court held the jury can consider all of the circumstances, even in the weeks leading up to the
So you're
homicide.
asking us to go way back when they first start this dispute, the social media, all of the things that happened before, and consider that as opposed to just what happened that caused him to shoot the Subaru.
Yes, Your Honor, and I think under Benavides, the jury is allowed to look at all of the
That
circumstances.
troubles me greatly because the society we live in today, if you've got somebody who's got, I'll use some some layman's terms, you've got a beef with somebody, and then they encounter somebody driving erratically, unrelated. Erratic driving will give rise to a defense here. And we have erratic driving and gunfire in the state of New
And
Mexico
it's not-
on a daily basis.
right, it's not just the erratic driving, it's Mark's belief that that is Louis in the car. It's not just any car that passes by. And New Mexico homicide law is concerned with the mental state of the defendant. It matters whether he just randomly shot into a passing car for no reason at all, or whether he acted, he believed.
Here, it's not no reason at all, it's erratic driving.
But it's
Because I
coupled-
think you have here a difficult time as a matter of law,
I don't think. so, Your
tethering
Honor.
what was, I know you're gonna disagree with me, but you gotta let me finish my statement too. We've got this history, but then we're gonna bless somebody, abusing illicit drugs so that they are crazed out of their mind and say, well, somebody cut me off, bam, bam. And that's going to be justified.
It's
And
not-
I have a very difficult time bridging that gap.
Right, but I think that is a determination for the jury to make. When we look at what is the objective component of provocation, that requires the jury to make a determination of would these circumstances cause an ordinary person of average disposition to lose control? And so the jury can weigh all of this, can say, well, he was high, that.
And wouldn't everybody get a jury instruction? Every time someone's driving erratically, and let's say I've been mad at Justice Thompson for a few weeks, and I say, oh, that must be Justice Thompson, so I'm just gonna shoot the car that I believe is Justice Thompson. I mean, that's so broad, and I'm concerned as well that any defendant could say, oh, I thought that was so-and-so driving erratically.
No.
And I was mad at him for a couple of weeks.
And-
He
and
was
Your
mad
Honor,
at me.
The role I'm asking for is rooted in fear-based provocation, not rage-based. And so I think that makes a difference because what we're saying is that Mark had reason to believe that that was Louis in the car. There's testimony about why they.
Where's
ran
the
a light.
reason to believe? It's a car he's never seen before. Every other witness that testified said that they didn't think it was Louis, or they told Mark to calm down and not get upset. where's the reasonableness in those sets of facts?
He testified that he believed that that was.
Right, but we're talking reasonable here.
He thought
So it's
that-
the objective,
Right.
reasonable person,
Well,
and every other witness said, we didn't think that was the case.
His reaction doesn't have to be reasonable, but the circumstances must be something that it would.
So I'm asking,
objectively-
what are the facts that make this reasonable? All we have is a car he's never seen before, and a bunch of people saying, I didn't think it was Louis.
He thought it was similar to a car that Louis had. Louis had a blue Nissan, I think, and this was a blue Subaru. So he thought it was a similar car, and he thought that his friend Jerome was was setting him up, was texting him while they were at the park, and thought he was arranging.
How do you meet? The provocation must be such as would affect the ability to reason and to cause a temporary loss of self-control in an ordinary person of average disposition. How do you get your client in the shoes of ordinary person of an average disposition as opposed to defendant's paranoia relating to intoxication from multiple substances?
And I think that is something for the jury to weigh. The jury can look at all of the circumstances, can look at what was happening leading up to this. There's all these threats going back and forth. Yes, Your Honor.
How is erratic driving sufficient provocation to get shot at and killed?
It's not on its own. It is not on its own.
Well,
But when he thinks he's being chased down by somebody who he believes is out to kill him, then I think it becomes sufficient provocation. In Taylor, the court said the question of whether the circumstances rose to the level of provocation to.
so if you and I are enemies, we're different gangs, and a car, there's erratic driving all the time, and a rival gang member that you know is a gang member cuts you off. Does that give you a right now to shoot that rival gang member?
No. But
You're
that's
gang
not,
members and you're rivals.
right, but that's not what happened here. Here, Mark was afraid that, and I think he had reason, there's evidence of why he's afraid that Louis is out to kill him. And he believes Louis is chasing him down the street, trying to kill him. And so the jury can look at all of those circumstances and they can weigh whether or not they think that is enough to cause somebody, an ordinary person, to lose control in that circumstance.
Can you address actually the issue that I'm having a little more questions about are the unanimous verdict and the self-defense instruction?
I'll start with self-defense. So that is related to the earlier shooting involving the Abetha family. The Abetha car was in between Mark and the Escalade. And under New Mexico law, the requirements for self-defense using deadly force are first, an appearance of an immediate danger of death or great bodily harm to the defendant. Brittany testified that she heard 3 shots coming from behind, and so that creates an appearance of harm, that the defendant was in fact put in such fear. Mark testified he was scared and he thought the Escalade's occupants were going to kill him. And then third, that a reasonable person would have reacted in the same manner. Mark and Brittany both testified that Mark fired towards the ground in response to those shots. So the critical issue was whether the jury would believe the Abetha's testimony that the Escalade did not shoot, or Mark and Brittany's testimony that it did, but the jury was never instructed that it had to make that.
Let me ask you, the state is arguing that, I think they're asking us to adopt it. Sorry. See, it's not you, it's all of us, about whether the jury found that he recklessly endangered innocent third parties.
Right.
I don't believe that's currently in New Mexico law.
No, I think we have cases that have allowed self-defense for a reckless shooting. There's, I think it's a 2001 case, Gallegos from the.
The request doesn't seem unreasonable. Will you address their request?
I think that recklessness and self-defense are just 2 different determinations for the jury to make, and where the defense has raised the issue of self-defense and presented enough evidence to support giving the instruction, then they're entitled to an instruction on their defense. And I don't think the fact that the jury found the conduct reckless by convicting of those charges means that they would have rejected a self-defense claim. And I think our usual law on defense requested jury instructions should apply, and that the court should have given the instruction in that case. That it has the similar transferred intent issue, but in Abetha, this court clearly said transferred intent applies to self-defense. And then for the unanimity instruction, the jury returned a general verdict for theories based on depraved mind murder and premeditated murder. And in an earlier case, State versus Salazar, the court held that this is constitutional. However, Salazar, the first case cited for that proposition is Arizona versus Shad, which was a death penalty case out of Arizona where the underlying convictions were felony murder and deliberate intent murder. And Shad was grounded in the inapplicability of the Sixth Amendment to the states at that time. That premise was rejected in Louisiana versus Ramos.
That's whether there's overall a unanimous verdict as opposed to the theory, right?
It held that there doesn't have to be unanimity as to the theory. Just overall, a verdict of first-degree murder is.
That's Salazar, but the Shad case was not addressing a unanimous verdict as to theory, it was addressing unanimous verdict overall.
Ramos was addressing.
Okay, am I getting the wrong name?
Ramos is the more recent case where Louisiana and I think Oregon allowed a non-unanimous verdict in it.
But Shad, the partial reversal in Shad is because it was based on former law that juror unanimity was not required to convict. That's very different than the kind of unanimity you're advocating for here.
I mean, it's not
It's not apples and apples.
right, I understand that, but I think where the United States Supreme Court has now recognized you have to have juror unanimity.
But the way that thread carries forward is there's a distinction between which act was the defendant convicted of versus which charge. When it's the same act and the mens rea, it's a question of mens rea. So how do you distinguish, how do you make, following the thread of your argument, what's your argument that this is more like Consol rather than more like Salazar?
Right, because if we look at State versus Dowling from this court, that discussed depraved mind murder and deliberate intent murder and held that those are basically mutually exclusive crimes. If you've set out with the deliberate intent to kill a particular person, that's different than this general disregard for human life. And in this case in particular, one requires the jury to believe Louis in the car. One requires the jury to believe that Mark didn't know whether Louis was in the car. And so I think.
But the result there's not any different, unlike Consol where there was a significant difference because the act was in question. We didn't know in Consol what the defendant was being punished for. Was it swaddling? Was it smothering? That's not what we have
I mean, here we have the shooting is the underlying act of both, but.
And if the facts support either outcome.
But that's where I think it's.
I'm sorry, I didn't mean to interrupt you.
No, it's okay. That's where I think it's.
Good
No, I think you need to answer my question.
Because, yeah.
That's where I think it's unfair because these are an entirely different set of circumstances other than shooting into the car. But what does Mark believe at the time? And what is
But the punishment's the same for both.
And in Consol, the punishment was the same for both. That was a child abuse resulting in great bodily harm case. And so whether he was convicted of intentional child abuse or negligent child abuse, it's a first-degree felony either way.
But Consol limits its holding to a situation where the act at issue isn't.
Not criminal.
Because swaddling's not criminal.
Right, but
That's
Smothering
felony
is.
murder, depraved mind murder, and first-degree murder are all first-degree murder.
Yeah.
Intentional, depraved mind, and felony, that's the difference.
right, but I think the underlying mens rea, and that's part of what's at issue in Consol also, is his mens rea at the time.
Can I ask you, this is what's also concerning to me. I'm not even sure this is the right case to be addressing this. This wasn't preserved.
That's true.
The jury was not polled. That would have been an opportunity for the defense to say, can we ascertain which theory they were under, if any? And now we're asking judges to sua sponte, come up with a special verdict form when the attorneys aren't even requesting it. So all of those things concern me about addressing this issue in this particular case. Do you have a response to that concern?
I mean, I think that, I just feel like it's unfair to allow a conviction where we're not sure which theory the jury went with, and that that counsel supports this. That the prosecutor in that case also told the jury, some of you could believe he did one thing, some of you could believe he did another thing.
I don't disagree with that idea in the abstract. I have often said, why don't we have special verdict forms in criminal cases? But it's because, and I'm pointing at both sides here, y'all don't want them. Because a special verdict form in certain instances it would be a disadvantage to the defendant.
Right.
And in certain instances, it's a disadvantage to the state. So you also, we don't want special verdict forms. We're gonna create this messiness. But now you're asking us to declare a rule that in this instance, you have to have a special verdict form. The logical consequence of that, I'm not sure from, kind of the defense world generally, would agree with that, because it will undercut your ability to raise issues on appeal.
In some cases,
I know, but we have to write a rule for all cases, not just this case. And that, I struggle with that, not in a positive or a negative way. I struggle with what do we do with that?
I think the benefit to the defendant of having the jury agree on what his mens rea was at the time outweighs those concerns.
Let the senior go, but I have a question about that.
Finally. So I think, well, my question is this. Yes, willful and deliberate murder is murder, correct? And depraved mind murder is murder.
Correct.
But they have different elements.
Yes.
And if a jury says, juror 1 says he committed depraved mind murder, that's a species of murder, but that's different than willful and deliberate murder. And so I think what you're saying is the state, when it makes the charge, they should be required to say, this is my theory, and not just throw everything to the wall and then get an instruction that lets them convict on any of those alternative theories, depending on how the jury sees the evidence as to mens rea. And mens rea is a critical element of any crime. And if crimes are committed with different mens rea, different evil minds, it's the same murder. It's a murder. The murder arises from A, the act of shooting, and B, the intent. But if the intent is different for different things, it's different.
But it's not different for first degree murder. I mean, felony murder may not have the same mens rea, but the legislature said if you commit it in commission of a felony, it's first degree murder. Same with depraved mind. The legislature said they are all punished as first degree murder. So this argument about mens rea doesn't hold water. It's all first degree murder. Whether he was shooting with intent, depraved mind, or in the commission of a felony, that's a first degree murder.
That's the same with any crime. I mean, we have a slew of felonies that are all punished as second degree felonies. You can't just instruct on 2 and say.
Well, right, but you don't have, counsel, you don't have a circumstance in which the legislature has said, these are so bad, I'm going to elevate it to first degree murder because of the mens rea.
That's the same for any
It's not.
degree of felony. There's a number of second degree felonies that the legislature has said these should all be punished, or first degree felonies. Kidnapping and rape are both first degree felonies. We don't say you can pick either one of those.
You have
They
a depraved mind second degree felony?
No, it's a
No.
first
Do
degree
you have do you have a felony in commission of a felony for a second degree felony? You don't. It's only first degree.
I don't understand that.
The legislature has said mens rea with regard to felony murder and depraved mind murder is not significant. It is a first degree murder.
But the legislature has not said, it was Salazar that said, we'll allow these to be punished in any combination, that you don't have to be unanimous as to the theory. The legislature didn't say that.
But that's
That's how-
that's this court's interpretation of what the legislature said.
Of the unanimity
Salazar.
doctrine, but,
So why have mens rea?
right, because it matters why, for a homicide case, it matters why the defendant shot into the car.
So then we should strike felony murder and depraved mind murder.
I don't think we have to strike
Constitutionally.
it, but we should
'Cause it
say
has no
the
measure.
jury has to agree. A felony murder is very different. It doesn't require, it requires an underlying felony, but not an intent to kill. It just requires your acts to be greatly dangerous. Depraved mind murder, you can punish an unintentional killing that way. These are incredibly different mental states that underlie felony murder.
Okay, all right.
Thank you, Your Honors.
Anything else? No. All right, thank you. Mr.
May it please the court, counsel. In a single day, defendant and his accomplices murdered Cameron Martinez, wounded 3 of his friends, and recklessly endangered the lives of William and Mary Abeta and their 2 young grandchildren. In the course of 2 shootings, they fired approximately 30 shots, with defendant accounting for 16 of those, and all 8 victims were completely innocent strangers. The state respectfully requests that this court affirm his convictions in all respects. So I'd like to jump into.
Can we affirm and still declare that provocation is available generally, the transferred intent for provocation?
That transferred, yes, Your Honor, it could still hold that the provocation here was insufficient and hold that transferred intent does apply.
And what about the defense's argument that factual question of whether the provocation was sufficient under, if there was a transferred intent theory, was enough?
Your Honor, this court has recognized in previous cases that sometimes it's not a question of fact. And
It can be
sometimes-
decided as a matter of law.
Yes, Your Honor.
And in what instances, can you give me examples of when the court has declared as a matter of law the provocation was insufficient?
Turning to, it's in the state's brief
Mhm.
that I'm just trying to get to very quickly.
I recall one that was like words, people yelling at each other.
Right. Some of the cases are said on page 19 of the state's brief. State v. Farrow, where a superintendent ridiculed the defendant, threatened him, and fired him. In Taylor, although that's a Court of Appeals case,
Mhm.
the mother disciplining the child with a slap to the face was insufficient. State v. Gaitan, that was a slightly different issue because it involved a sort of first aggressor sort of rule, but the court still recognized there has to be enough evidence to make that reasonableness determination and found the defendant.
It seems to me that some of those cases, the facts are, if we talk about the facts here, in this case, those cases, the facts are even less. Me yelling at you and using curse words, not being sufficient provocation as opposed to what was happening in this case with the flashing of guns and different messages that I had to have younger people explain to me what they meant. It seems that there is a potential factual distinction between those cases where the court ruled as a matter of law provocation was insufficient and the facts here. Why should we rule as a matter of law here that provocation was insufficient, assuming we get over the transfer intent portion of this?
Yes, sure. So the state's position on that is those were very easy cases, but that this case still falls within the same gambit. Because defendant on appeal, as contrary to what he was arguing below, you recognize, okay, the driving, that doesn't count. That's just insufficient as a matter of law. So it's only when you start looking at subjective mental states and what the defendant subjectively was afraid of.
As opposed to the objectively reasonable person.
Right. And so there we're just purely considering the defendant's subjective mental state because of particular circumstances unique to him, not a reasonable person of average disposition who's put in there. So defendant testified enough factually that he satisfied the subjective prong, but he's still got to meet that objective prong. And these rules serve important purposes. So like the restriction that provocation must come from the victim and this reasonableness requirement, they're not just arbitrary things this court has come up with. It's because manslaughter is recognizing that there's a class of homicides that is less culpable because society is willing to recognize, okay, that conduct was pretty extreme. A reasonable person, we're not going to say was justified in the killing. There's still a penalty associated with it, but society is willing to recognize that it's less culpable. And so here, where you have to just consider the defendant's particular subjective mental circumstances, you have to then chain it together with the driving of the victim's car, not even the victim, but the other person driving it, and then make the further jump to the victim. That's far too attenuated. That's not the purpose of the
How do I square all of that with Sloan and the use notes in the UJI?
Your Honor, clarify as to the victim, or what exactly?
So we've got case law that says this is well-settled law, there's no transferred intent. And then we have use notes which have the force and effect of law in the UJI that says something different. It says it can be the provocateur or somebody else.
Your Honor, I think the best view of the kind of transferred intent and transferred provocation and what we make of Griego is that with manslaughter, a defendant who's convicted of manslaughter can't then get up on appeal and say, hey, you couldn't convict me of anything because I meant to kill some other guy. That the doctrine of transferred intent would still apply there. And if you look at Griego, and actually the quotation that my friend on the other side cited to, it's talking in terms of transferred intent. But if we're looking on the front end on whether provocation and must come, it still must be personal. And this court decided 4 years ago, it must come from the victim. So in the state's view, that's the best view of New Mexico law as a whole. That's a reasonable policy choice in Sloan because it serves as one of these important internal limitations on the doctrine. And there's no conflict to recognize. The defendant isn't entitled to an instruction, however you cut it.
So let's say we change the Sloan rule to apply to someone other than the victim. Where would we draw that line? That's what my concern would be about looking at Sloan and whether this is even the right case to do it if we were considering it. But where would that line be drawn? Just the people that were there at the scene? Would it be other people?
Your Honor, I think that's a very important point. And again, it's not as if New Mexico courts came up with the victim restriction just because that's a nice neat line. But I think because if you look to all the conduct in the world, it very quickly gets tough. I can't think of offhand a principle where you draw a principled line. And it seemed like from defendants' arguments on appeal that they are trying to argue for a very, very broad interpretation. We need to look at this morning shooting. We should look at the Facebook posts. We should look at the entire history and context of his relationship with Louis. So I think that does very quickly become unmanageable because then we have circumstances like Your Honor's identified where somebody does something entirely innocuous that society is not prepared to recognize as extreme conduct that would cause a loss of control in an ordinary person, but because of a defendant's subjective history and own particular circumstance, they view as this very frightening thing. Without some sort of line drawn that may cause hardship in some cases, but not in others, it's a very difficult inquiry, and it would erase the objective component, essentially.
So I could, as a defendant, say, I'm going to pick on Justice Thompson again. Justice Thompson, 4 weeks ago, pointed a gun at me, and I drove on I-25 and saw a car, and I was pretty sure because they were driving erratically, and Justice Thompson scares me that it was probably him, so I shot.
Yes.
And that's where I'm starting to get concerned about this. Where do we draw the line?
Yes, Your Honor. And I think those are very legitimate concerns. And I think that, although, bright line rules can look harsh sometimes, oftentimes there's a reason for it, because where do we draw the line? I unfortunately don't have a good answer for the court. So if the court has further questions on manslaughter,
I understand your thing about societies prepared to recognize certain conduct as threatening and maybe not other conduct as threatening, but let's take gang members again, where they've got a way of communicating with each other through hand signals or signs that mean things, or I'm going to get you. To me, it may mean nothing, but to a gang member, it may mean a threat. Should we recognize those kinds of things?
yes, sir. So that would be essentially asking for and I'm not making light of your Honor's question, but the sort of reasonable gang member view. How particular can you define the reasonable person construct to get to things like that? I think in the proper case, that might be an interesting question, but here we don't have any sort of, there were coded messages. This is just defendant saw a car and associated with somebody completely different.
Given the questions we've asked about unanimity in the jury verdict, do you have anything to add that's already been said?
I guess I do have a few points of clarification or summary. As the court noted, I forget which of your honor, this is a bad case to decide the issue where there's certainly no preservation, probably waiver, and we're deciding it just on fundamental error. So we'd be saying district court, by not deciding an issue that was never raised and one that's permissible that you decided in a permissible way under state precedent, we're going to say you fundamentally erred. This isn't a good case for that inquiry. So as to how Consul, and I apologize if I butchered that name, is distinguishable and how do we fit that into Salazar, there are a few key points. One ways in which a few key points of difference. First, Consul was talking about a case where the state had completely different and incompatible theories as to how the defendant committed the crime, not just mens rea, but the entire act. And importantly, here we're talking about crimes that are not just punished at the same degree, but this court has held in Salazar, they're the same culpability. So the state's argument will, for the purposes of this case, this court doesn't need to decide whether mens rea can never serve, but in this particular instance where this court has held, where the difference is only mens rea, and this court has held that the mens rea difference, they're equivalent in culpability, this isn't a case that calls for it. Further, there was substantial evidence for both theories. And if it helps the court at all, the jury also convicted defendant of conspiracy to commit murder. So, and it would be difficult for them to conspire to have a depraved mind with respect to loot. So this is a bad case to decide the issue if this court is interested in the issue in the abstract. As to, unless the court has further questions on that, I'd like to move to the self-defense issue. So to clarify, the state isn't asking this court to hold that when the state prosecutes someone for a crime with the mens rea of recklessness, they never get a self-defense instruction. I think even under the state's rule, in the lion's share of cases where you're a district court judge, a defendant asks for a self-defense instruction when they're charged with a mens rea of recklessness, they do get that instruction because it would be a jury issue. But here we're deciding whether the court reached the right result for the same reason. And we have the unique perspective into the jury's mind. We know that they were instructed on reckless endangerment and what that standard is. And we know that the jury found beyond a reasonable doubt that he recklessly endangered the abetas. So it's, as one of your honors noted, this is a pretty sensible internal limitation on transferred self-defense. Doesn't appear to be incompatible with any state precedent because although this court has discussed I think it was Sherwood, that the 1930s case where it recognized, yes, self-defense can transfer. It didn't attempt to cabin or really define and say it may transfer under any and all circumstances, no matter how reckless the defendant is being. So this is just a sort of important internal limitation on the rule that's recognized as black letter law by the authorities that defendant points this court to when discussing that. And it makes a great deal of policy sense. So the state thinks this is an appropriate case for it. So
you're talking about the fact that they found defendant guilty of shooting their motor vehicle, they necessarily had to make reckless
Yes, Your Honor.
And therefore the instruction.
Yes, Your Honor. And wouldn't have even been qualified to get it under the circumstances.
And then just looking at the three elements that we look at, I guess the one I would have the most question about is, you know, whether the two subjective elements we look at, whether that was I think there was testimony, so I think they met their burden there. But what about the third one? The defendant acted reasonably, he or she shot at victims. Do you think there was enough evidence presented to that would have allowed him to have instruction, or do you think it's a matter of law?
The state takes the position that spraying 7 shots on a busy highway, even when you think somebody's shooting at you, that's reckless. And that would decide that third element. And this court could take that route to decide this case. It could say, well, the state asked us to adopt this other rule, but we think the evidence was insufficient on that third element to entitle defendant to an instruction in the first place. That is a bit of a different argument than the state has articulated, and I apologize for that. I'd like to now move to the unit of prosecution question as to shooting at or from a motor vehicle. So under this court's precedent, we first looked to the statute and we applied the canons of
We
construction.
just cut to the,
Yes, Your
to the question here. Why isn't the rubric found in Chief Justice Nakamura's opinion in Ramirez, why doesn't that just shut the door on your response? Or why doesn't that shut the door on the double jeopardy question?
I think it's important to read that decision in light of Benally, I believe, is this court's recent clarification about the rule of lenity and the role that plays in kind of transitioning between the first and second step. From Ramirez, it seems to be that the court laid out, here are 2 possible constructions of the statute, and we think it's close enough, so we'll proceed to the second. It's the state's view that there's an insurmountable ambiguity such that we would have to consider indicia of distinctness. So it's the state's position that it's clear when you consider all the canons of construction, and that was another issue in Benally. When we look at the unit of prosecution, the fact that it's only a 4th-degree felony to recklessly endanger somebody's life, the public policy goals behind the statute, the fact that you would have to have this artificial distinction, even under the text of the statute, you'd have to create an artificial distinction that even defendant recognizes when you charge someone with shooting resulting in an injury versus not an injury. Under their view, you could properly charge multiple victims with multiple counts, but if you don't endanger anybody, that's simply a course of conduct. And that is an artificial distinction, completely alien to the text of the statute. And if this court, even if this court thinks that there's, after considering the statute, that there's some ambiguity, and maybe this court could have some slight discomfort saying, well, maybe it makes sense in some cases to have a per victim unit of prosecution. Maybe sometimes it makes sense to have a per shot or a per shot per victim or something like that. What's clear is that defendant's interpretation that this is just a course of conduct fails, that there has to be some consideration of the number of victims or shots fired or some combination thereof. The state submits that per victim is the most natural way to read the statute. So just to jump back quickly to provocation and manslaughter, it's worth looking to defendant's testimony, paying attention to that, and identifying the point at which he said he was provoked, at which point he crossed the line from being very scared to pulling the trigger. And it's worth remembering that it was defendant's shot that killed Cameron. What pushed him over the edge wasn't the Subaru's driving. That scared him, but it didn't cause him to pull the trigger. What caused him to pull the trigger was Axel firing. He blamed Axel for firing first and making him react. So there's another way this court could resolve the provocation issue. This is just Sloan. That an accomplice provoked the defendant to shoot. An accomplice's actions cannot constitute provocation as a matter of law. So that's another way this court could deal with that issue. Just to reemphasize, even if this court...
Getting back to your last point, if I remember right, Axel said he was asleep.
Yes, sir.
So he denied being the first shooter.
Yes, sir, under Axel's. But taking defendant for this purposes as to whether he was entitled to an instruction. Just taking him at his word, he blamed Axel. That was his story. So unless this court has any further questions, the state respectfully requests that this court affirm defendant's convictions in all respects.
I'd like to address 2 points on rebuttal. First, the state's argument about self-defense and recklessness related to the Abatha shooting. The state asked this court to look at what the jury convicted of and then look back on whether they would have found self-defense. And that's not the standard of review that this court uses for a preserved jury instruction error. The standard is whether there's enough evidence to raise a reasonable doubt in the mind of a juror. And here, where Mark admitted to the shooting, of course they're going to convict him of shooting at or from when they don't have any option to find a justification defense. And then second, I would like to address the discussion about provocation as a matter of law. The state pointed this court to Farrow and Ferris, where the court found that evidence was not enough as a matter of law to get a jury instruction. And both of those cases involve far less threatening conduct than was at issue here. And so I think that's where transferred intent, this idea becomes very important, because if we look at all of the circumstances, then there is certainly enough evidence.
And let me ask what I asked the state, if we get rid of the rule about the victim being the source of provocation, where do we draw the line on the mistaken belief that the person driving the car is like, how long?
I think-
Months, years?
I think generally, if we look at Benavides, which was the 1980 case from this court, we allowed the defendant to present all of the circumstances. I think it was weeks between the defendant and the victim. He stole a TV, he got his son addicted to heroin, he threatened that, all of this conduct leading up to the homicide. And so I think that's relevant here too. And then it's up to the jury to determine what they make of those circumstances. They might think objectively that wasn't enough to cause a reasonable person to lose control, but that is a jury question. Whether the objective analysis as part of provocation is a jury question also.
Let me take you back to where you left off right before Justice Moore asked the question, talking about provocation as a matter of law.
Mhm.
What about the state's argument, which at the very end here, where he says, look at the defendant's testimony.
Right.
He says, I'm scared, I'm scared, I'm scared. And then he says, what caused me to shoot
Mhm.
was Axel's shot.
Right.
Why doesn't that make
I think if that was the only evidence that he was pointing to, that the only reason he fired into the other car was because Axel shot, and that's the only thing that made him afraid, then I think this would be like Sloan. But instead, we have all of this other conduct. And then also that testimony was disputed. Axel said he didn't shoot first. He was asleep, and then he woke up.
You want me to take your client's testimony,
Right.
In the light most favorable to him, supporting everything he said.
Mhm.
So you can't have me do that and ignore.
Right, and I'm
testimony.
not
I don't know
asking
how to I don't know how to thread that.
I'm not asking you to ignore it, but I think we can look at all of what happened first and say there was sufficient provocation even before Axel fired his shot. And
So that the things that happened before, we can ignore what's happening with the Subaru. And that would be reasonable, because if we buy Axel's testimony, your client only shot because of what had happened previously, not because of what was happening real time. And I'm not sure that gets you to reasonable provocation.
I think the jury's just allowed to consider all of these circumstances and to make these credibility determinations and to weigh the evidence. And that's consistent with the general law on when the district court should give a defense requested jury instruction. If there are no further questions.
So I'm thinking of a situation, domestic violence, or one of the partners is constantly abused over weeks or months or years, and it's all preceded by a look. And the defendant says, I saw that look and I knew I was going to get it again, so I shot.
Mhm.
Is that kind of what you're talking about?
I mean, I think that would fall kind of under more of our battered spouse syndrome self-defense cases that allow a look at what are the.
Or provocation, that look?
Mhm. Yeah, I think if it's then up to the jury to weigh whether that's enough to mitigate the killing.
Is it your position that a district court could not direct out the first degree charge or at a preliminary hearing conclude first degree was not met if the defendant stood up and said there was provocation? Is that also good?
It would depend on if there was sufficient evidence to meet the probable cause standard for whatever theory of first-degree murder the state.
This is a question for the jury. Provocation is a question for the jury, correct?
Correct.
So could a district court say this crime was not committed without sufficient provocation?
Could they decide as a matter of law there was sufficient provocation? Is that what you're asking?
To the point that the state can't bring the elevated charge? Or would they have to say, no, I'm leaving it to the jury?
I mean, I think you have to look at what is the evidence of the first-degree murder charge, because you could have a murder. I mean, most murders are probably second-degree murder. So you don't have evidence of a deliberate intent. You have evidence of an intentional killing, and then you have maybe some evidence of provocation. So I think if there's no evidence to support the first-degree murder, the district court can direct out that charge and then let it go forward on the lesser. Thank you.
All right, counsel, thank you for your presentations today. The court will be in recess.